Jacinda.
Thank you, Mr. Chair. I want to come back to two amendments that I wasn't able to address in my first contribution. The first sits within Part 1, and it talks around the definition of those areas where there is jurisdiction for the coroner to investigate a death in official custody or care. And this issue wasn't something that was discussed in great length directly by the Select Committee, but we inadvertently, I think, stumbled across some definition issues when we were debating deaths in custody as they relate to those who are under the care of child, youth and family in a residential facility. And the discussion that was had was why was it that when going back, and this arose off the back of the bill as it stands in Part 2, changing the criteria to allow the coroner greater discretion around whether or not a death in custody is an inquest or an inquiry. I had a selection of coroners' reports around deaths in SIF's care, which I had OIA'd on a previous occasion in order to better understand some of the child protection issues we have here in New Zealand. Within that stack, it became clear to me that there was a real difference, range of areas in which a coroner had opted for an inquest over an inquiry, and I found that very confusing. My thought was, look, my understanding was currently it's always going to be an inquest. Why was it that we had so many examples of coroners' reports that were indeed inquiries for children who were in SIF's care? And the answer lies in Part 1, because in Part 1, if we're looking in 1B, it states that in Section 9, replace the definition of a death in official custody or care, and then it has the definition, and it states a child or young person who has been placed in a residence within the meaning of Section 2.1 or 364 of the Children and Young Persons and Their Families Act 1989, whether or not the death occurred in the residence. And then it goes on to a description of a child or young person who is in the custody or care of an iwi social service, cultural social service, a residential disability care operator, or the director of child, youth and family support services, and so on. What the definition doesn't say, so clearly here the indication seems to be a young person who's in a residential facility of some description, whether or not that's operated directly by SIFs or is contracted to operate by SIFs. What my question is, why does the definition simply not state a child who is under the care of the Chief Executive? Because that would then cover those who are in residential facility via perhaps youth justice, or whether or not they are in foster care, or whānau care, or kinship care, or home, perhaps not home for life because that's not technically. But if we had that broader definition within Part 1 that simply stated a child who is under the care of the Chief Executive under the definition of the Child, Young Person and Their Families Act, we would therefore have had greater consistency in the way that we treated those children. And we wouldn't have then that discretion between when coroners were conducting inquests and inquiries. Now, as it happens, actually that now is slightly null and void because this bill is giving that discretion regardless of whether a child is in residence or kinship care or so on. But our hope would have been that we would have treated all children in care the same, because I would wager that it is in the public interest for an inquest to be held any time a child is harmed to the point of death when they technically come under the jurisdiction of SIFs, regardless of whether they're in a residence or not, regardless of whether or not they meet that current definition or not. So in Part 2, we'll argue that we shouldn't have that discretion around inquest inquiry. If you're in custody, it should be an inquest. But I still have that definitional issue in Part 1 around, even then, is every child who's in the care of the Chief Executive covered by those provisions? I'd be interested to hear from the Minister if I have wrongly interpreted that definition. The reason that I extrapolated that was because in some of the departmental, Mr. Chair,
Sandra Dern.
Mr. Chair, I will be brief.
You'll be next.
Oh, yeah, sorry, Minister, but I'll be very brief. I'll add one more question or statement to the mix. But the reason I raised that issue is because when we were having this debate, the advice that we received from the department did point to the definition of official custody and care in the Coroners Act as the reason for those differences in the reports from the coroners that I was referring to in the first part of my contribution. My second very quick reference that I wanted to make really just highlights, I think, an unfortunate amendment that was made from the original bill as it was drafted by the Minister, and it relates, I touched on it earlier, the role of pathologists. Now, I found this a particularly compelling piece of evidence that was provided to the Select Committee, and it relates to Clause 18, which says Section 27 amended, family may request pathologist report on post-mortem. Now, what it really intended to do was narrow the range of family members who can receive a pathologist's report down to immediate family. But what we ended up having quite a substantive discussion in the Select Committee about was another section that was being inserted after 27(1), and that was, as originally drafted, a pathologist may, at the request of a member of the dead person's immediate family, contact the family to explain or answer questions in relation to the pathologist's report. Now, we had pathologists or those from the National Forensic Pathology Service strongly welcome the fact that something that was informally happening within the system, and the pathologists came in and gave very compelling evidence that they were having those kinds of discussions with families but without a statutory footing. And they welcomed the ability to be able to communicate with family members directly. And point out countless examples where they literally had family members there waiting, and how awkward, of course, it is for a pathologist to say, look, I cannot speak to you or I cannot communicate. So look, in practice, that was happening anyway. So they welcomed that. However, at Select Committee, we had the Chief Coroner submitting that the clause as drafted was allowing direct contact, which they felt actually needed to be facilitated by the coroner. Their view was that they had immediate responsibility for the final outcome, and therefore that it would raise difficulties for them if suddenly there was some statutory footing and for the pathologist. So the Chief Coroner submitted that Clause 18 in its entirety should be deleted, and that everything should be facilitated via the coroner. The midway point that the Select Committee eventually came to, although it's our view that the original drafting was correct, was to insert clarification that essentially means that everything, all that communication must still go through the coroner. So what we might have is what will seem like a farcical situation, a pathologist saying to a family member, I cannot relay any information to you until I'm able to contact the coroner and then communicate. And you can imagine in those stressful situations how difficult that will be for both the family and the coroner. So I believe the original drafting was right. I believe it put the informal practice on a statutory footing, and based on I thought the pathologist's evidence was compelling. It's disappointing that has been redrafted, and I would be interested in hearing the Minister's views on that also.
Chairman?
The Honourable Amy